All right, guys, welcome to another amazing episode of the WLG breakdown of the industry. Today, we have the amazing John Miller with us, going to give us a deep dive on trust administration. If this is your first time here, I want to give you a little introduction to who the Wellness and Legacy Group is. We are a group of professionals that are dedicated to creating a streamlined process for the death care industry, ultimately uniting our industry as a whole. When you think of the death care industry, you may be saying, Carolyn, what the heck are we talking about here? This is a little diagram that we have created as we've been journeying down this learning process from the pre-planning side. Death is amongst us all. It's inevitable. It's part of life. It's always been a rather taboo subject or something that we don't talk about as regularly as we should. So our group aims to really open the conversation up and really find out how it all works and what we should be doing. So we have been successfully, we've basically categorized it into pre-planning, then into aging and how do we age well, and then once we do pass away, what are the post-administration side and the business side of passing away, right? So our group and vision is really to create a seamless connection between the wellness industry, the pre-planning industry, which serves individuals prior to death, and then the legacy industry, which supports individuals and families post death. What our group has recognized is often these sectors serve the same customers, the same time, sometimes simultaneously. And our group aims to under a deeper understanding about the collaboration of all these critical stages of service and ultimately unite our industry together. So we've got quite the task at hand, but we are doing it. We've created this mastermind of industry professionals, which is what you are watching today, where we are meeting with each individual department in this administration process and hearing it from the horse's mouth, if you will. These are people that are daily practicing in the field that can provide you information as a professional and also as a consumer. So without further ado, I will go ahead and unshare my screen and I will welcome to our virtual stage John Miller. How you doing today, sir?
Hi, Carolyn. I'm great. Thanks so much for having me.
You are welcome. You are amazing contributor to this our group, and you already have actually spoken with us regarding originally as a real estate law and how to properly transfer your assets without having to even have a trust or even go through probate. So that was a very dynamic information last time. So I'm excited of what diamonds you're going to drop on us today. So if you wouldn't mind, tell everybody a little bit about who you are, your law firm, where you practice, and then we can jump in.
Thank you so much. Yeah, I'm John Miller, and I started my law firm in 1991. We are located in Ponte Vedra Beach, Florida. We've always been at the Jacksonville beaches. And we do three things: estate planning, which we're going to talk about some today, which actually can include probate, but hopefully not. We do real estate, as you know, and we love representing entrepreneurial small business owners. All three of those areas do tie together in nicely. And so our firm tries to create the business, the family, and the real estate side of a person's life and weave them together. Got a team of, I think, about 10 in-house and a few remote supporters of the team. And we just love what we do. And of course, I love being in connection with you and your team and the group. It's such a fantastic idea to tie all of these professionals together where we learn from each other about the things that some of us do every day.
Yes, and I like to also mention you're a really fun group, okay? There's always a good time when you're hanging out with John, okay?
Thank you.
Yes, very, very cool. So let's go ahead and jump in today. So the topic of today is really to talk about more so the post administration of the trust process. So we're out, advocating for families to set up a trust, right? It's part of the estate plan. Get a trust set up, get a trust set up so you can avoid probate. So now let's assume for our talk today that the family has done just that. They've set up a trust and they have now passed away. The first question is, what is one of the first things that a successor of a trust would do?
Sure, great question. And if we are in the trust administration phase, that means we've already won, right? Because if we've been able to help that client, and I know we're going to talk some about funding, get their assets into their trust, that means that we're avoiding court, the probate process, the expense, the delay, and the hassle, including infighting that goes on at court. That means that somebody has taken the time to protect their legacy, to plan for the future of those that they love. And typically, the scenario that you framed this question around, if it was a couple, we've now had the second member of that couple pass away. The survivor has passed, and now it's a what do we do? Well, during their lifetime, typically, the couple together are trustees, and the trust is likely revocable. And then when that first member passed, it either became irrevocable then or becomes irrevocable at the death of the surviving member. So probably the surviving member continued to control the assets throughout his or her life. And now we're at a point in time where the both members of the couple are gone, or candidly, it could be that they're no longer capable of managing their affairs, and the successor trustee will be appointed. Now, I'm going to answer this by going back a little further in time. One of the things that Rock Solid Law and Title does with our clients is offer to educate their fiduciaries. Ooh, that sounds like lawyer talk, but what it is we offer to tell the people that they've wanted to name to take over for them what their job's going to be, so that suddenly everybody's gone and it's not, oh my gosh, what do we do now? But having practiced law 40 years, it often is, oh my goodness, what happens next, right? What do we do? Hopefully, we've talked to them on the phone. Hopefully, the folks that set the trust up in the first place have let them know who's out here to help them. Now, candidly, any qualified lawyer who practices in trusts and estates is going to help be able to guide that trustee through the process. We've helped with people who we did not prepare the plan. Often the person, the lawyer who prepared the plan is either retired or no longer with us either, because obviously many of these were prepared many years before. I would say it might be a first choice to have the firm that worked on the plan in the first place to help administer it because of their familiarity with it and with the language that's in the trust, but it's not absolutely necessary. So, unless this is a professional fiduciary, somebody that regularly functions as a trustee of a trust, I would say the first thing that a person needs to do is reach out and get a professional together, an estate planning attorney who can help guide them through this process. And depending on the complexity of the trust, that could be a very minimal involvement, or it can be quite an entangled and lengthy involvement, just depending on what's necessary. While that's probably an attorney, the team will also need the financial advisor that was serving the decedent, as well as probably the CPA who has worked with the trustees of the trust in the past, or a CPA that the new trustee is used to working with. So, as is appropriate from the group that you meet with, we are combining the services of multiple professionals, right? to get this person who's now the trustee guided in the right direction as they begin their journey of following the rules that are set forth in the trust for the distribution of whatever assets are in that trust.
Right. So just to kind of break down some of what you said. So preferably, the person that created the trust would have an ongoing relationship with whoever created the trust. Like if your law firm, if you create a trust for someone, you offer them the services to connect with their fiduciary, connect with their trustee. So that way it's not a shocking matter. Hey, in the event I pass away, this is who you should call, so they have some type of relationship, right? That would be best case scenario. Then you would
100%.
just Yeah, then you would just reach out to whoever your family set up the trust with. But like you mentioned, life is not always, how we planned for it. So it could be that they set up the trust many years ago. Whoever set up the trust never reached out to the trustee. There's no relationship there. So you're saying that when you go into your family's file cabinet, because not everybody talks about this stuff, your family, mom, dad, they can have a trust set up and they just have it in their file cabinet. They've never had a formal conversation. I'll use my own family as an example. My in-laws, I know that they have something set up, and I say something, right? Because every time they go on a long journey somewhere, they're always like, all right, guys, if anything happens, all the paperwork's on the counter.
Yeah.
But where's the dinner that says, "Hey guys, why don't you come over and let me go over this stuff with you?" Right? It's very elusive,
Mhm.
So I don't if the families have the communication, which obviously that's what we advocate for, right? Talk about it, get your trustee involved so it's not this big mystery at the end. But whether whichever way it works out, their first step most likely is to reach out to the attorney on the paperwork or a attorney that they're comfortable with handling business, right?
Absolutely. And Carolyn, I might add, particularly older generations often kept wealth conversations out of family conversations. Um, so that it's a complete mystery to people. And, we have to respect the decision of the client if they don't want to share. Um, but we ask at least to be introduced to the person who would be taking over so that it's a less than awkward first phone call and that
Mm.
they feel they have a helper on the other end of the line when they pick the phone up.
Starting place. Yeah. So, as of now, from what I've heard of speaking with, so many different people, these documents are just kind of like in your file cabinet, in your drawer, right? Which in the world of technology that we're currently living in, that seems so antiquated, right? It seems as though there should be, but for the most part, like you said, wealth has been not something that we talk about at the kitchen table. It's in a file cabinet. It is what it is. So, okay, now let's talk about they've reached out to the attorney. What is really those next steps? You're reading through the trust. Maybe the trustee is unfamiliar with anything. Um, what then? What does that next step look like?
Well, hopefully, and in the best case scenario, the person that set the trust up has done what we refer to as funded the trust. And I know that you know what that is. But
Mm-hmm.
funding, if I were king of estate planning, I would have called retitling because it's simply making your assets titled into the trust because
Mm-hmm.
your successor trustee only has the ability to control those items that are in the trust. So the first thing is to determine what the trust owns. Now, in many cases, the trustee was also named as the personal representative. So if the person who passed away failed to fund all of their assets in the trust, then one of the first things that that trustee's going to need to do is put on their personal representative. In other states, they call that an executor
Okay.
hat and go and marshal those assets Unfortunately, that's through a probate action. However, it's a much more simplified probate because the result of that probate is put all the assets in the trust. Then that personal representative takes off that hat, puts on their trustee hat, likely the same person in most scenarios, and now is in charge of all of those assets. So I'd like to just point out one of the things that Rock Solid Law does as part of every trust plan is helps the client with funding the trust, moving those assets. Because folks, if you do a trust and you don't put your assets in it, you have basically an empty suitcase and you just left for a trip abroad with no change of clothes. Okay. So it's really important. And many, many, many law firms merely give a slip of paper that instructs people to go fund your trust. We know that's ineffective. Okay. Statistics show 90% of people are so relieved that they've done their estate planning that they will never get around to moving the assets. So it's so important. And this is exactly why, because now you've got a trustee who is suddenly in charge of all of your assets. And oh my goodness, there's some of them that aren't in there. And so they've got a whole nother job, and that involves going to court. So that's why it's so important to get those assets in there so that the trustee can go, okay, I've got control of all of this stuff, because the trustee is only in control of what's in your trust.
Right.
The
I've
next
heard
step will be read the trust, because that's where you put your rules in effect.
Right. I've heard of people, going and getting a estate plan done and they just walk out with like a big binder. And it's like, well, you're not finished. Like your job is not done. And so I think that's great that you hold their hand through that process, because what was the point then? Like, you got, a big binder, but there's nothing in there. And people need that guidance, like, hey, your life insurance policy, who's listed as the beneficiaries, your stock accounts, who's listed, right. So
Right.
if we assume for this talk that the trust was funded, right?
Great. I
Uh,
like it.
yeah, because like you said, and that was great information, is that if it wasn't funded, then the personal representative, you'd have to open up a probate. The personal representative would have to go collect the assets and ask the probate court to put it into the trust, not into the beneficiaries' names, right? Like you
Right.
would in probate.
Right. If you wanted to leave something directly to someone, you could put them on an account that's not in the trust and leave them as beneficiary. That will pass outside of probate. The risk there, of course, is disequalization of your assets among your heirs. But maybe you've decided, I want somebody, could be the person who's going to be your trustee, to have this pot of money to take care of whatever issues come up. So that's one way of managing that factor.
Okay. So let's assume that it is a funded trust.
Okay.
They were working with Rock Solid Law and they have the perfect estate plan set up.
All
Um,
right.
yes. Is there any legal notices that have to be sent to beneficiaries? We contacted the lawyer, we've reviewed everything that the trust owns. Now do we have to disclose it to the beneficiaries?
Sure. The first thing that's going to be done is a notice of trust filed with the clerk of the court. That's the
Okay.
only thing that's required to be done as far as the government. And that way, it's been stated publicly that there is no need for a probate. That's what we read in there, is that there is a trust here. And that puts the world supposedly on notice the trust exists. Now, what we're going to do with that successor trustee is review the firms of the terms of the distribution of the assets that are inside that trust. And once we do that, we will also become aware of who the beneficiaries are. Sometimes someone has predeceased, right? And so we have to look at that trust and see, okay, what happens to that person's share? Is there another person who's a beneficiary? Perhaps their child. Perhaps if they don't outlive, it goes to the siblings of that person who predeceased. That's entirely up to the person who made the trust and how the trust was drafted. So now you know what the group of assets are. And then you're going to read and find out who the beneficiaries are. The trustee would then notify the beneficiaries that they are beneficiaries of the estate. Those beneficiaries are entitled to see the trust. Okay. Up to that point in time, nobody's been entitled to see what's in the trust. Why do we do it that way? Because we want them to be aware of what they're supposed to be getting so that the reality matches what was intended by the grantor or settler, the person who drafted the trust. So that you're going to notify those people and they have a right to be notified. In fact, if you know you're a beneficiary of the trust and the trustees, keeping the cards too close to the vest, you can demand that they provide that to you. And hopefully they would do the right thing, but a court can force them to do so as well.
Mm-hmm. Interesting. So the only formal court notice is saying there is a trust in place, and then the trustee would have to just give notice. It's not really a formal notice per se. It's just their due diligence as being a trustee to communicate, share with them what they're inheriting or what has to be administered.
Exactly. Because one of the beauties of the trust is it doesn't air your laundry to the public, right? It doesn't go through a court. Your nosy neighbors can't, they can go look at a will, right? But they can't go look at a trust. It's not required to be recorded anywhere in the public records. People always ask me, or often ask me, after they do a trust, now do we record this with the court? And I say, no, no, no. One of the things you've done is you've kept your private matters private. You know,
Mm-hmm.
often often people will split things. I have 3 kids. I'm going to split it 3 ways, but often they don't. Maybe somebody's a brain surgeon and the sister is a teacher, right? And the other, and so they decide, well, this person's really successfully financially and they don't need as much as the other. I don't know. There can be many, many things in a trust. We also, of course, we have people that have special needs and we have people that have special spending habits, I'll say, and
Mm-hmm.
the parents can rein those in. They don't have to treat each child or other beneficiary, each heir, the same.
Mm-hmm.
So then there's going to be a determination. Okay, when when did they say to distribute assets? It might not be any right now. It might. What if the kids were still minors, right? So maybe it's you're going to be giving distributions to their guardians so they have money to take care of them if that's what the trust says. They're going to eventually, most likely, pay for college education and even graduate school sometimes, depending on what they put in there. Of almost every trust we've ever drafted is going to indicate that if medical needs were necessary, any assets that were in the trust would be available to pay for those. Of course, you wouldn't want to have money sitting there and a child or other beneficiary who needs medical care not to be able to access the money in the discretion of the trustee. So, I mean, I think we can all imagine medical wishes that are not necessary that they might ask for, and the trustee can decide whether they need to have those procedures or not. But certainly anything that were medically necessary, in my opinion, it'd be unreasonable for the trustee to withhold. So
Mm-hmm.
the trustee is going to determine, or we're going to help them look at that and say, well, when are the distributions? And we're going to be working with the financial planner where the money was held. Most people they trust somebody to manage the money. They want the accounts at the same place. So, for instance, if a child's not going to get a distribution until they're a certain age, maybe 30, the money remains invested for for growth. So it's even more when that person inherits it.
Mm-hmm.
Um, and a lot of people will say, it's in the trustee's discretion, but I want to state a preference that my long-term management firm remain involved.
Mm-hmm. So that's really interesting because, we think about maybe
And maybe
like,
real estate,
mm-hmm.
right? Mhm. Go
Yeah, I
ahead.
was gonna say it's very interesting because, in essence, when you set up that trust, like in probate, it's kind of like assets are distributed effective immediately. It gets put into people's names, it transfers the ownership, and boof, it's done, it's gone, right? But in a
Right.
trust,
Right.
right? It actually just starts life, right? Like it could be as easy as, hey, give my house to this person, give this to this person. But if you are actually setting up a comprehensive plan of how you want your assets to be administered throughout the time, right? It's not going to be over in just, one transaction.
Right.
Are you, as the lawyer, are you typically like on that case, like as long as the trust is in effect, or what is your position in that?
Yes, but not as actively as that sounds, because typically there's a lot of activity right at the beginning. And, it's kind of like setting the course of the sales for a long passage, right? So you get it set, they know what they're doing. They feel comfortable in their role. They know what their fiduciary obligations are. And what that means is that the trustee has an obligation to act not in their own best interest, but in the best interest of the beneficiaries of that trust, right? So once they understand what to do and how to do it, then we're not going to be that involved unless and in case they need us. Now,
Mhm,
as an example, many trusts that we have been drafting since the arise of the opioid epidemic in our country
mhm,
will contain what we refer to as the bad behaviors clause. So if the trustee thinks that a beneficiary is becoming addicted to legal or illegal substances, the trustee has the ability to provide rehabilitation for that person. The trustee also will be uh, under the requirement to withhold payout, because you don't want to enable that person to continue down a course in their life which is destructive. So
mhm,
that is if the parents have decided that's what they want. And candidly, most of them do, right? Now that those are available, we typically, with the approval of our clients, draft them in, and then they can draft any part of it out that they don't want.
mhm,
Some families have different values, and it's not up to us what they value. And sometimes they make exceptions.
mhm,
Um, uh, some people enjoy their cocktails and they don't want to restrict, they don't want to tell their trustee to be concerned if their turns out to be like them. But they would, of course, be concerned with a serious drug addiction. So,
mhm,
we do our best to draft around those sorts of things. That might be an instance where a trustee comes back to the lawyer and says, "Okay, I'm not really sure how this works. Let's walk through this, obviously legalese language together, so I can understand exactly what it is I'm supposed to do." And so I properly tell the beneficiary what the rules are under the
mhm.
trust.
So if in essence, I mean, really the power player is that trustee, right? I mean, they're really the ones that are overseeing this. That's quite a position, isn't it?
It truly is. And you know, some families have a person. It doesn't have to be blood family, but it can be. It can also be a friend, a relationship, who are who share the same values as the person that made the trust,
Mhm,
and who have the ability to put into effect the requirements of the trust, right? Um, so that's, I often say, we share our values through a trust, and this is a point where choosing that trustee is so important, because it really should be someone that shares your values and is going to apply the rules that you have set forth in the way that you meant them to be applied. It's not a wink, a nod, and a nudge, right? It's like, it's not okay to ignore the things that are in the trust and distribute however the trustee feels like it. It's
mhm,
really important that someone is chosen who will follow that. I call it a playbook or a rule book of how
mhm.
to distribute those funds, how and when not to, as well.
What are your thoughts on, having a professional trustee versus a personal trustee?
Carolyn,
Like,
I didn't quite get that question. Would you ask it again?
Yes. What is your opinion on establishing a professional trustee, like a
Sure.
fiduciary, opposed to doing a friend, family?
Excellent question. Um, and lawyer's favorite answer, it depends, right? It really does depend on the setup and structure of the family. And candidly, it depends on the level of wealth being left behind, right? Because uh, obviously, a professional trustee is a paid position, as well it should be. That's a tough job. And a lot of that job is saying no to sometimes to people who are feeling entitled or greedy, or I don't know which term someone would want to use, but can be rather demanding, can spend a lot of time requesting or begging for things. I do not serve personally as a trustee, but I work with a lot of them, and I hear a lot of the stories and the I knew I couldn't give her that money, but she really wanted it kind of tale that we hear. So it's an excellent choice to choose a family member. It's likely going to be cost effective. And I'll talk about fees for trustees in a minute. But because of the personalities, family relationships involved, and in some families, there's just not really an obvious candidate. It is really important to then look to a professional. Now, for people with significant degree of wealth and who are willing to have that wealth under the supervision of a particular institution. Many banks and trust companies do, of course, have a trust wing that can serve in that capacity. And some of them are very good at it. It's just important to take a look at the cost benefit analysis of that relationship. There are also private individuals who are bonded and are trained and can serve in the capacity of a fiduciary trustee or otherwise that can be less expensive than a trust company, that may be a great alternative uh, to um, to a family member or friend being chosen. It really, and why I say it depends, is it depends on that family, it depends on that person, it depends on who they have in their lives that have the skill to act as a trustee and can be trusted to act for the benefit of the beneficiaries rather than for their own. May
Right.
I just segue into fees?
Yeah, sure.
So a trustee should be paid, candidly, in my opinion. Um, we encourage clients typically to incorporate language that a trustee should receive a reasonable fee for their services. That reasonable fee should be related to how much money they're having or value of assets that they're having to to execute on, to be in control of, and candidly to be liable for. Right? I mean, well, let's just face that straight up. We are in a litigious society, and the trustee is taking on a fiduciary responsibility for which they may be sued. And candidly, in my experience, most trustees do a good job, but there are bad apples, and those bad apples should be sued or replaced. So we encourage people to write language in that the trustee should receive a reasonable fee. Um, Reasonableness, of course, is subject to some construction, right? But at the time you write a trust, you don't really know when the successor trustee, or you absolutely don't know when the successor trustee is going to have to act. So you don't know what a fair fee would be. A
Right.
lot of times it's related to a percentage of the value of the assets in the trust, for instance. Um, Now, I will tell you that in my experience, and let's just say I graduated law school 40 years ago, so I've been
Been
at
around
this for a
lots
minute,
of
and
times.
most most close members of family, siblings, those sorts of folks, will either decline a fee altogether, or they'll take a very reasonable fee. Because a lot of times they really just are doing it sort of as a service to the person that they love that appointed them. I will say, though, that even those that decline to accept a fee are appreciative of the fact that the grantor uh, drafted in language that said that they should be entitled to one. And I
Mm.
will say to people who say, "Oh, I wouldn't dare take a fee for that," I'll say to them, "Wait till you see how much work's involved." Right? Because if all the kids are now beyond the age of the last distribution and it's just dividing it up and cutting a few checks or
Yep.
having investment accounts retitled into their names and is not much work, okay, fair enough. But if you're having to month after month and year after year spend part of your life uh, governing those assets, man, there should be a reasonable fee. And if people don't take a fee, tend to become bitter about it. They're unhappy about the imposition on their lives. And so I think it's very reasonable to leave them an adequate fee to take care of that for you. If you didn't have some degree of assets in the first place, then it probably wouldn't be necessary to think over a great period of time how that's distributed.
Right. That's excellent because that's really the big distinguish, is that with a trust, it can live on for many, many years. It doesn't just end when you pass away, such as like a probate or something to that nature. The family keeps the assets in that trust and could continually be making money. Distributions are set at different ages. So you talked about, the banks kind of being like one of those first positions, I guess. Is that because they are sometimes the ones that are handling like the investments and the accounts within that institution, and then they just naturally have that department of trustee? Um, is that really why they kind of just get put into that position in your experience, or?
Yes. Yeah, and not every institution has a trust department, of course. And some of them do, and some of them do a tremendously good job of managing the assets both for the growth of the future generations. And you know, they are professionally trained in that role. So
Mm.
they understand exactly the duties that they have to the trust and to the beneficiaries. And they're going to, in my experience, very, very cautiously carry out all of those duties and obligations.
Yeah, very more professional, just straight business. There's, because that's what I see. Like, if you make a trustee one of the beneficiaries, it could be emotional. That's was one of my questions here. We kind of are scooting our way to it. But how are disagreements within the trust, right? Which, do disagreements happen? That's what is the first part of the question. I think I already know the answer, but do disagreements happen in a trust, and how are they handled?
Sure. And of course, they can sometimes, but I will say that in my experience, um, disagreements are more likely to come out on the probate side
True.
when the beneficiaries or litigants are already teed up and in court, and you know some fairly ridiculous motivations from decades before can really drive those disputes. He always liked you better anyway. You were always the favorite, blah blah blah. And you see that come out in ridiculous ways. Now, one of the reasons that we encourage people for whom a trust is appropriate uh, to create a trust is so that you have written the rule book. And I find that beneficiaries, for the most part, are more likely to accept that than they are the rules of court, for instance, and the the fairness of the Florida statutes on the will side. Um, However, there are disputes and there are ways of settling the dispute. The trustee has a lot of leeway, and you are exactly right. In many instances, they've chosen one child to be the successor trustee, and that child is also a beneficiary. So they've got to be very, very careful um, not to administer the trust so that they gain favor, because
Mm-hmm.
if they do, that's absolutely actionable and is a breach of, it can be a breach of fiduciary duty. So in that case, a lawsuit could be filed under the trust. It's just that there are more hoops to jump through and a higher standard uh, uh, that the trustee is held to in under its fiduciary duties. Now, before a lawsuit's filed, depending on how the trust is drafted, there may be a trust protector, which is typically a law firm, often the one that drafted the documents, and the beneficiaries could come to that person, that lawyer, and say, listen, I don't think what's going on is being done fairly, and I need you to look into that. And the trust protector can look into that. And if the trustee is indeed acting in violation of their fiduciary duty, the trust protector typically has the power to replace them as trustee. It can be set up other ways, like the majority of the beneficiaries can vote out a trustee, which has the same, checks and balance effect of making that person, if not naturally inclined to do so by the law and by the fiduciary duty placed upon them, to toe the line, because they know that they could be replaced, and then they'll really be on the outside, right? I would imagine, and I have, thank goodness, not had this, but a trustee who is, managing more for their own benefit than that of the other beneficiaries, who's replaced, may find themselves conversely on the short end of the stick in the future, depending on who that replacement trustee is. So there
Mm-hmm.
is an opportunity for resolution before litigation, but ultimately, filing a lawsuit is is going to be the way that that beneficiary can hold the trustee liable for their breach of fiduciary duty.
Right. So less likely of disagreements because the everything's already been spoken very specifically, right? Unlike
Yeah.
probate, you do have a will, but that's up to, subject to, the court administration of, what happens after someone passes away. Um, so there's less disputes, but like you said, still trusts are held close to the chest and they are not discussed. So then when they are revealed, I could assume in some cases that some people are not happy with the way that things were laid out. Um, I hear it a lot in probate. They're like, oh, well, that they created that will, like, there's a lot of, whereas with a trust, it's like, well, this was done, with a lawyer, this was funded, this was all, it leaves less for disagreements. But so if there is a disagreement or you're not happy with how everything's laid out, potentially that beneficiary could into a lawsuit against the trust
Yes.
at that point. Okay.
Yeah, that the lawsuit would be against the trustee. And again,
Okay.
we don't litigate at my firm, happily so, in my opinion, although
Mm-hmm.
we will do non-litigious probate. In other words, families that just need the help to get through a probate, we're happy to help them.
Mm-hmm.
If the beneficiaries want to have a fight, we have some good lawyers we refer them to. So,
Mm-hmm.
yeah, that would be a lawsuit filed by the beneficiary against the trustee. You've probably heard of that or read of it in celebrity magazines and things where that
Right.
happens occasionally. And yeah, it's also sometimes referred to as busting the trust. If somebody thinks that, oh, maybe the trust was done under duress, or for some other reason there was undue influence wielded when the trust was drafted, certainly someone could sue to have a court take a look at that.
Mm-hmm.
But one of the main things we want to do in creating a trust is to avoid that uncertainty of litigation. But I still argue we have the best court system in the world. And so if a true dispute does arise,
Right.
that's the arena
Due
to get
process.
resolution.
Right.
Mhm.
So as we start landing the plane on all this, and this has been incredible, really understanding the intricacies, the nuances, even the simple fact of, oh, I went and got an estate plan, but you didn't fund the trust. Okay. What are some things in your, as you said, 40 years in practicing, what are some things that you have seen when people bring you trust agreements, may not have been things that you've written up, right? But they come to you. What are some things that leave the trustee or the successors in a pinch um, that we can have on the?
Great question. So the biggest thing is I will receive a very beautifully bound notebook, probably 3 to 4 inches thick, and a couple that's maybe getting a little bit up in age says, "We've got this, but we have absolutely no idea what it is and what's in it." So, thankfully, when you get that, when they still have competence, you can help them through that process and help them fund things in it because those same that same fact scenario usually leads to somebody that wasn't helped with the funding aspect. And we have an employee designated to do that. There's
Mm,
one person here, and we've trained her to know all about funding. And if she doesn't understand something about funding, she comes to one of the lawyers or paralegals, and we help her figure out how to do that correctly for them. So that funding piece is a big deal. I wasn't as always as fastidious about helping my clients get funded until I saw the fact pattern over and over and over again and realized there's a real problem here. And so we're not going to let our people live with that problem. And that's how we came to the conclusion that we were just going to include funding as part of the
live
work we
or
do.
die, right?
What's that?
Live or die with that problem,
That's
right?
right.
It,
I, I've had
it
about two
doesn't matter
people,
until you pass
or
away, right?
right. I've had about two people talk me out of it. But the good news about a properly drafted trust package with a pour over will is that the minute they leave my office, if they were very sadly, and it's never happened, in an accident that day and died, the pour over will exist. So everything would end up going through the trust and pursuant to the rules that they drafted. So
Mm.
once it's fully executed, there really is a sense of relief that we've got a viable plan, it's in place. But let's fund it so we don't have to deal with the courts to get that piece done. Um, I
So I was gonna
Yeah,
say,
go ahead.
John, that pour over will, in the event that you said they left your office, they got the pour over will, they have the trust, but it hasn't been funded. That's where that's the process that you said we would go to probate with that pour over will, and we would assign everything into the trust. Is that part?
Exactly. The pour over will basically says anything that I do not leave in my trust, if I leave it in my individual name, and by implication, that means that doesn't have a death beneficiary on it, I want to be moved into my trust after my death. So if it has a death beneficiary, as you well know, it's going to pass outside of the probate process and go directly to that person. Sort of like life insurance proceeds, just as an analogy. It's different, but it works the same way.
Mm-hmm. Okay. So, because the trust itself is basically setting up the rules and regulations, right? It's setting up what the distribution is, what the things are that you're requesting to happen, right? When they walk out of your office, that's what they walk out with, what the plan is for when I die. But if they don't put the assets in, that's the only element that's missing.
Right. Exactly right.
Okay.
Yep. Yep.
Perfect. So besides not funding it, is there anything else that you see as a common mistake with trust?
Well, when it's unfunded, people just continue to operate as the way they did before they got to us. Um, I really do think the communication piece is appropriate, and I do respect people's decisions to keep their finances private. But um, uh, you could communicate to the, let's just say, successor trustee, but really any fiduciary that's appointed as part of your estate plan, your healthcare surrogate. You can educate them on what their duties are without telling them about, whether it's $600,000 or 20 million that they're going to be governing. They don't need to know that. And they don't even need to know what distribution plan you selected, as long as you teach them what their duties and responsibilities are. And I have people very regularly who are, oh my gosh, I'm this now. What do I do? I'm trustee. What am I doing? Right? How I have no idea what to do next. And we're like, okay, we got you. We can do this together. And let's just get together as quickly as we can, right? And and move forward working through whatever the rules are that are set up. So um I I, I don't have a really good other horror story on trust administration to share with you. Um, although, for complete lack of planning, all sorts of bad things can happen. And, for
Right.
people with a certain degree of assets, it really does need to be in a trust because probate is going to be such an expensive process and really deprive your heirs of access and amount of the value of what you meant to leave behind. Nobody wants to pay more taxes or give more to the government or give more government control over what they leave behind after this life. I mean, that's we Americans love to argue, but nobody says, I want the government to be in charge of my assets or estate, and I want to pay more taxes than I have to, right? So
Exactly.
that's what we try to help people get through. Um, a failing to plan. Uh, let me see if I can get this one right. Couples married, lived a long time. Unfortunately, one of them got ill and passed, and they had a son, and unfortunately, he had a sports related brain injury. Um, they had a decent amount of wealth, and after an appropriate, extremely appropriate period of time, um, the surviving spouse remarried and had a daughter. That surviving spouse lived a long time. And the daughter grew up to be stunningly beautiful and married a rock star. And that marriage went the way a lot of rock star marriages go after a period of time and didn't work out. But that young woman, uh, independent, in fact, very wealthy. Unfortunately, the parent of the brain injured boy passed away. And so the second spouse lived on, the parent of the girl. And when that second spouse died, the girl, who was already wealthy, inherited everything. And
Mm.
that the child of the first marriage, who had needs, was literally unintentionally, but disinherited. So
Wow.
that's not an evil people story. That's a lack of planning story. And the failure to plan is really throwing what happens in the future open to something really a negative result like that, or a significant portion of your assets being gobbled up by the state, by professionals who have to come in and deal with an ill-planned estate afterward. And it's gonna be 10% of the estate if you go through probate, and often it's greater than that. It's not by law 10%, but the statistics show it just is uh,
Right.
uh,
Right.
over time.
Yeah, and I think between, like what you do is, helping them fund it, and then I've heard another lawyer state, they like to get with their customers that they do estate planning with once a year, you know. And I think that makes so much sense because our lives change so much. If
Mhm.
I did my estate plan 10 years ago, my kids are grown. I don't even live in that house anymore. So many things can change. And similarly, if it's not funded or it's not updated to reflect the current circumstances, um, and I think about stuff like, what if the trustee, passes away, and then, I'm sure you have a subsidiary in the trust, as if this person passed, then it would go to this person, right? But
Right.
like, how would that then be appointed? You're not here, right, to really be a part of that, and those are probably where trust things can get complicated, right? um,
Sure. Yep.
People, other people passing
Yes.
away, and the redistribution of everything based off of, and it's crazy, right, John? Because all of this is a guarantee, right?
Yes.
It's like,
You know
yes,
what's
we
going to
don't
happen.
know. Yeah, you don't know the date and time, but it's coming,
Yep.
right? Um,
Yes.
I think more of these conversations, especially us as our group, having these conversations openly, it then empowers us to, you work in this field, this is what you do for a living every day. I work in the aftermath world, where it's more of the administrating of the real estate, what needs to be done now, how do we get this organized? But you're working in that, pre-planning, you're the one starting the conversation, let's put it that way, okay? All the
Yep.
pressure's on you,
Yep.
John, okay?
Yeah. Well, a lot of people feel a lot of pressure, but I was just with a couple today. They are not old compared to me. They're really not old, and they had done a will some years ago, as many of us do when they started having children. And it's now they have a different scenario, and it's time to do something really an upgrade. They need all sorts of things, asset protection, and now they want to talk in terms of a trust as well. And they said, well, we basically did it the first time because we figured we ought to be adulting. And I love that. It's just sometimes it's time to adult. And one of the things, me and my team, Carolyn, but we really try hard. I call my firm Beach Professional. You get professional services, but you get a beach attitude. So I try really hard to make the conversation, although it does have to talk about our ultimate transition, right? Our death, uh, to make it not dour. There's a lot of life between now and then. And I find a lot of people have a lot of peace inside
Mhm.
themselves when they have taken this step and they know that things are going to be well managed.
Yeah.
And what we're talking about today is continuing that flow, right? I said at the beginning of the session, wow, if we're doing trust administration, we've already won, right? There may be some more bumps coming, but we've created a super highway instead of a pothole filled dirt road
Mhm.
for those kids to travel down. And, you know, we just try to make that conversation as normalized as we can and know that it's about passing your values forward to the next generation, as well as your assets, of course. And
Mhm.
that makes it a lot more palatable for people. It's not such a hard thing to talk about once you get into the nuts and bolts of the conversation.
Well, we're part of the revolution, John.
That's
So
right. We
thank you
are glad to
for
be here with you.
yes, thank you, John, so much for your knowledge. It's always a joy. I took a ton of notes, and I'm excited to present this to the group. So again, thank you a million. Keep rocking
My
on.
pleasure. All
Okay.
right. You
Great.
rock too.
All right. We'll see
Thank
you on
you.
the next one. Thank you, John. Have a nice day.